I'm very happy to be here this afternoon. My name is actually Teresa Bakkner, and I'm with the law firm of Whiteman, Osterman, and Hanna in Albany, New York. And I've been doing land use and planning for about 25 years now, which is a really long time. But on the positive side, it's very interesting topics. Now, I know everybody expects to be bored in the case law update section of the presentation, and I hope to surprise you. First, I need to know, besides Mitch, are there any other attorneys here today? Oh, very few. Okay, good. Well, I'm going to, sorry, no offense, no offense. Because I'm going to talk a little bit about some concepts related to case law, because I find that if you talk about cases, but you don't talk about what all the terms mean, it's impossible to understand what the lawyers are talking about. So I'm going to encourage everybody here, if you have a question, raise your hand. If you have a hypothetical situation you want to talk about, raise your hand. We want to make this interesting and interactive so nobody falls asleep before lunch. You should at least wait to do that until after lunch. All right, so the first thing we're going to talk about is what you all do. And what you all do as people who serve on planning and zoning boards is you deal with all of the issues that are most important to your community. Who here likes to see their best team lose? Does anybody like to see their best team lose? Nobody likes to see their best team lose. The last thing you want to do is lose a case. If you've made a decision, you want to make it stick. Now, there's always somebody out there in New York who's willing to challenge the decision that you've made. In the 25 years I've been doing this in upstate New York and the Hudson Valley, there have been more and more and more and more lawsuits. And it's truly said that you can sue a ham sandwich in New York. It's very easy to sue. So, and people also don't like change, and there's a very a significant view in the community that everybody's home is their largest investment. So everybody's always very concerned about what happens from a land use standpoint. So whatever decision you make, your goal should be that it should be judgment-proof. So one of the first keys to making a judgment-proof decision is make sure it's within the scope of your authority. Now, I see some people here who shall remain nameless, who I represent as a planning board. And we always have this conversation, which is stay within your area of authority. So if the question is this allowed in this zoning district? That's not a question for the planning board. That's a question for the code enforcement officer. If the town board has zoned an area for a particular use, and somebody comes in for a site plan approval, well, then you apply the site plan approval criterias. You don't talk about whether or not you like the particular use, because it was the town board's decision whether or not the use is allowed. And I don't mean to say that you can't have your own opinion. It's just that in your role as a board member, you have very specific rights and responsibilities. And here's some key concepts, and I apologize for my voice. One of my partners gave me a cold, so it's his fault. One of the important issues are comprehensive plans. What you will constantly hear is that whether or not a project is within the scope of the comprehensive plan is relevant to your decision making. And you're going to hear this concept as part of the case law analysis I'm going to get into here. And the other issue, of course, is what standard applies. So you have different standards for different decisions, for site plan, for subdivision, for variances, and also for waivers that can be granted often by planning boards. There are also issues related to procedures. And this is the area where everybody always sues on, procedures, failure to follow procedures. You have to do public hearings, you have to do notices, You have to do referrals to adjoining municipalities and to the county under the general municipal law. And you'll notice as I talk about these cases that this is an issue that comes up again and again and again. So if there's one thing you do as a planning board or a town board or a zoning board of appeals is making sure that you file those appropriate notices will go a long way towards making the judgment the decision that you make judgment proof. Then we get into another area of law, another term, which is called standing. Who here has heard the term standing before? Whether or not you have standing to bring a lawsuit. Standing is different depending on whether you're in federal court or state court. It's different depending upon the interest that you're alleging has been damaged. But the basic rule is that you have to allege an environment, you have to complain of an environmental injury that's different from the public at large. So you have to have a unique injury that you can plead in court papers. And then the second part of that test is that your injury has to fall within the zone of interest sought to be protected or promoted by the statute. So the best and easiest examples, and because we get to pick our examples, I can pick an easy one, is if somebody comes in and challenges the decision of the planning board to approve a project, they live next door to the project, and they allege that the project will create noise at a level that is a significant environmental impact, and that significant environmental impact was not addressed during the review, a court is going to find that they have standing. On the other side of this, if somebody lives 20 miles away from the project, has never been near the project, and alleges a generic damage like a visual damage, as in, I drive by here on Route 30 every 3 days, and this is how I'm damaged, chances are the court is not going to consider that to be different from the public at large and an insufficient allegation of an injury. There's also some interesting things that you find as a planning board come up, and that is when economic competitors raise seeker issues. Right now I'm representing a municipality, and one of the people that are opposing the project is another asphalt plant. So we have an asphalt plant that's asking for an approval, and then we have the operator of an existing asphalt plant who's challenging that. And the courts have very clearly said an economic interest is insufficient to establish standing. So you can't just allege that it's going to be bad for your business. What type of lawsuits do you see? What type of ones are we going to talk about? There's really two approaches. One is a declaratory judgment action, and the other is an Article 78, which I'm sure you've all heard of. And generally speaking, the cases fall into the category of Article 78, which is whether or not a decision was arbitrary and capricious, whether it was decided in violation of the procedures or was affected by an error of law. On the declaratory judgment end, it's more on the issue of a lack of authority. It actually gets to the constitutional basis for the adoption of a particular rule or regulation or issuance of an approval. So the declaratory judgment issue generally comes up in the context of town board decisions, because planning boards are just implementing the laws as they've been set forth by the town board. So who's here who's on a town board besides Herb Litz? Herb's the only one here, okay. I won't pick on you then. So when you get to the next issue that comes up frequently in these cases is segmentation and cumulative effects, which you find people alleging a lot in court cases, but they're very rarely upheld because there's very specific ways that you can avoid creating a situation where you segment a project. So I'm sure everybody here has had people stand up and say, well, you're segmenting the review of this project and it's inappropriate. But only if you have a situation where something is dependent upon a future action do courts generally find that you have segmentation. And so you really look at, is it included in a long-range plan? Is it something that's more likely to be undertaken in the future, or dependent? So, and the best example of this type of case is DEC several years ago did a review of a transfer station and a landfill. And then they subsequently segmented off the transfer station, primarily because the plans for the landfill were so speculative and uncertain. So it is possible to do that, and you really have to ask yourself if the environmental review that you're undertaking for the transfer station is just as environmentally protective as it would have been if you looked at both projects together. So we'll talk about some cases involving this. So the first case we're going to talk about is a case where the village of Pomona sued the town of Ramapo. And the village of Pomona sued the town of Ramapo because the town changed its zoning so that you could have multifamily residential projects in an area next to single-family residential projects in the town. This happens all the time. It's very frequent where you have inner village and town disputes about the scope of projects. And this raises a lot of the issues that we've already talked about. The town went through the seeker process, had an EIS, adopted a seeker statement of findings. They amended their comprehensive plan, so their comprehensive plan showed that this was an appropriate use for this part of the town, and they amended their zoning, and the zoning allowed the multifamily housing. So the village alleged that there was spot zoning. They said that that it was inconsistent with their comprehensive plan, and therefore it was spot zoning. And the court determined that it was not spot zoning because the town had gone ahead and amended the comprehensive plan and taken a very holistic look at the location of multifamily housing in this area. So the court determined initially that the village could not make the argument that they lacked standing to make that claim, because the comprehensive plan is there not to protect adjacent villages and towns or counties, but to protect the interests of the people that live in the town itself. All right, the next issue was that the village raised was through seeker an impact on community character. And the court determined that it was a claim that the town could make that the village could make against the town, that they had failed to take a hard look at community character, because that could affect the village and it could affect them disproportionately from other governmental units. Then the next issue that the village raised was a general municipal law issue of failure to refer to the county and to provide the appropriate information. And since the purpose of the county referral is to look at regional impacts, the court determined that yes, the village had standing to raise that issue, because the very purpose of the statute and the procedure was to ensure that those regional impacts were examined. So does anybody have any question about that case and what they did or didn't do in it? Okay. The next case we're going to take a look at, which is a little bit more interesting, is the Anderson versus the town of Chilai. Chilai is out, I believe, towards Rochester, very proximate to the Rochester International Airport. And this case is very interesting to me because it's a Court of Appeals case overruling an appellate division case. And the reason why I picked this case to talk about is because it stands for the proposition that if it looks like a duck and quacks like a duck, the courts are going to say, hey, you didn't look at a substantive environmental impact. So it's not all about procedure, all right? Under seeker, you can raise substantive issues, and if they're significant enough, the courts will look at those issues and they'll overrule the local decision maker. And again, we've all agreed that's a position we don't want to be in. So the planning board, in this case, tried to do everything right. They were entertaining an application for someone to build a building which was going to be used for scrap metal collection, treatment, and then redistribution. The planning board had its own planners to advise them. They filled out all the right paperwork. They filled out the environmental assessment form, parts 1, 2, and 3, and they issued a negative declaration in writing, which was, on any other case would have been considered well-reasoned, well-written. However, during the course of the proceedings, there was an issue raised about the risk of explosions that occur in a scrap metal facility. Because they're compressing metal under heavy pressure, if there's any fuel left in a car or a truck, occasionally, in spite of everybody's best efforts, there's an explosion. And the issue that was raised was, are we concerned about the possibility of an explosion happening at this location because we have airplanes flying over the scrap metal facility? So anybody think they should have looked at that issue? Put your hands up, put your hands up. So they definitely should have looked at that issue. And the problem was, even though they had information in the record from the fire department and information in the record about the risks associated with the scrap metal facility, what they didn't have was a written, well-reasoned elaboration of why it wasn't too dangerous to have a scrap metal facility under the approach of an airport. So in that case, even though the appellate division upheld the decision of the planning board, the Court of Appeals did not hesitate to say, no, no, no. We're going to send this back. We're going to remand it back to the planning board and to the lower courts for them to look at this specific issue. So the reason why I mention that case is because procedurally you can do everything right, but if you miss a significant issue, you're still subject to challenge, and it's still possible that a court could substitute its judgment for the planning board under these pretty unique circumstances. Why did I pick this case? To show you pretty much what you have to have a court substitute its judgment for a local planning board. So in like 90% of the cases, you will find that the appellate division in particular supports the local municipal decision. But there's still that 1% of cases where there's going to be a substitution of judgment where it just looks bad, it just looks dangerous, it looks like something that should have been examined closer. The next case we're looking at here is Save the Pine Bush versus Common Council of the City of Albany. You all know, I'm sure, that Save the Pine Bush is a well-known, locally recognized entity that sues municipalities within the Pine Bush area of Albany all the time for approving projects which will adversely affect the pine bush, and particularly some of its endangered species like the Karner blue butterfly. So they've been bringing these lawsuits for, since the beginning of seeker, I would say the past 30 years. So this is one of those rare instances where, again, the Court of Appeals looks back and says, does it make sense that people who've demonstrated their commitment to a particular area in a city and town would not have standing. And the court says, they developed a new test here, which is the more than most. So what you have to do if you're an environmental group and you have a demonstrated interest in an area is participate in the seeker process for a long time, bring lots of lawsuits, and then the courts will determine that you have standing. Now, the interesting thing about this is the Court of Appeals reached out and found that the Save the Pine Bush had standing, but then they turned around and they said the claims didn't pass in this case. So although they got the opportunity to stay in the lawsuit and to have their claims heard, they in fact lost. And one of the reasons why they lost is this concept that the courts are going to defer to the municipal bodies making the decision, and you don't have to look at everything. So being obsessive compulsive about environmental issues as part of the environmental review is not required by seeker, okay? What you're supposed to do under seeker, and what Dave and Mark talked about earlier, is you're supposed to look at the big issues. You're not supposed to look at every issue. You're supposed to look at those that are significant, okay? And this is true, and DEC is pushing people to do this, particularly in environmental impact statements. You know, pick the issues as part of the scoping process that you know are of a concern. Traffic, stormwater, drainage, noise, odor. Don't force applicants to waste time on issues that are really not going to give rise to a significant adverse effect. So in this case, the Save the Pine Bush were arguing that although the city had looked at Karner blue butterflies, frosted elfins, adder mouth orchids, and traffic, that was not good enough. They also had to look at snakes and toads. And the court said, no, we're not going to say they had to look at snakes and toads. They had a reasonable reason for focusing on the Karner blue butterflies, the frosted elfins, and the adder's mouth orchids, because those were threatened and endangered species. And they articulated a good reason for not requiring the applicant to look at the snakes and the toads. And the reason, practically speaking, was simply that they live underground and they only emerge whenever it rains a lot. So the court said it was a reasonable decision. They had looked at everything they needed to look at, and it didn't need to be an encyclopedic look at the world. Whoops, sorry, I went the wrong way. Okay, the next case, a very interesting case. Interesting to me because I sort of watched it happen before the town board of the town of Rotterdam. And in this case, the town board of the town of Rotterdam entertained a request for rezoning, which was arguably consistent with their comprehensive plan, but they went through all the appropriate procedures. They issued a negative declaration, and they granted the rezoning. But what the court found that they didn't do was they didn't look at the reasonably anticipatable effects of the action, which is, okay, you're going to rezone this. How is the site then going to be developed? It was a relatively small site. It was clearly going to be developed for commercial purposes. And the court found that the board did not look forward ahead to the issues that were likely to come up when they looked at site plan review, such as maintaining an appropriate buffer between the project and the neighbors who were nearby. So they were really close to making it all the way through here on the rezoning. The court deferred to them in every respect, but the problem was that the court could not point to anything that they had looked at about the eventual future development of the site. And it was clear from the record that was established that they were planning on coming in for an additional approval. So how do you deal with this issue? Well, you deal with this issue by not only looking at the generic zoning change, but you look at the project that's going to result from the generic zoning change. Now, you're not required to speculate, and we'll talk about another case where there would have clearly required a lot of speculation, but where you're going to allow a new, more damaging use next to a residential use. Even if it's consistent with the comprehensive plan, you really need to look at the environmental effects of the eventual project. And this was what the board said, that they should have not deferred consideration of the criteria set forth in 617C until the submission of an actual proposed site plan. So it wasn't only that the town board deferred looking at it, it was that they specifically said that's what they were doing. When you think of the concept of deferring, what always helps me is it going to be with the same board or is it going to be with a new board? If you're pushing off the decision making to a new board, like it's going from the town board to the planning board, then what you really have to be careful is that you've covered the environmental issues before you presently, rather than saying they'll be handled in the future by somebody else, because that's what the courts are very concerned about. Okay, spot zoning. Anytime somebody asks you to rezone something, somebody always stands up in the audience and says, oh, you can't do that, that's spot zoning. And the reality is there are very few cases where the courts have determined that an action is in fact spot zoning. It's pretty rare. If you think of it, well, not to be confusing, but if somebody asks you for a use variance, they ask the Zoning Board of Appeals for a use variance, whatever the Zoning Board of Appeals says, it is very difficult if they issue a use variance for that to be upheld if there's litigation, and it's very easy if you say no to defend that decision on the use variance because the standards for getting a use variance are so high. So that's pretty much the most difficult approval to get from a town. However, when you're in the legislative arena before the town board, the courts are very likely to defer to the town board on rezoning issues. They may find procedural problems, but generally it's within the purview of the elected town board to make those decisions. So in this case, there was a textual change in the zoning law that would allow additional special permit uses of plant, nursery, and arborist. And what the people who opposed it said was, look, this could only be for this particular business, therefore it was spot zoning. And the court said, no, that's not right. It's a textual change in the definition of what's allowed, and there are other properties within that zone which could be used for plant, nursery, and arborist. So that's not spot zoning. And they also took very strong notice of the fact that there was no evidence presented by those making the case of any detriment to the surrounding properties. So that kind of tells you what the court looks at. They look at, for spot zoning, is it just going to affect a very tiny property in the middle of a property that's already zoned residential, and it's going to cause problems to those residentially zoned properties? That's one of the rare times when the court may find that spot zoning has occurred and that it's impermissible. But again, recently we were in front of a municipality where we were indicating that we wanted to rezone 500 acres of property. And we got the question, well, isn't that spot zoning? And we kind of just pulled our hair out because 500 acres, per se is not spot zoning. That's a huge area of a town. That's whatever it is, and it may be illegal for other reasons, it's clearly not spot zoning. All right. Oh, and it's interesting in this case. The courts are very, they bounce back and forth on this issue. Sometimes they say failure to timely file a referral action to the county is just a procedural irregularity. Sometimes they say it makes the decision of the board void ab initio, which means void from the beginning. So again, with the county referrals, all I can say is do them right. The question is really, is it an area of the town that's currently zoned for something else that is going to cause a detriment to those properties surrounding it? And generally, the size of the parcel that's implicated is under an acre. So when somebody claims spot zoning, I'm not saying spot zoning never occurs. I'm just saying that the vast majority of the time that you'll hear those two words, it's not happening. Okay, taking a hard look. This issue comes up a lot because there are some substantive areas that planning boards are comfortable looking at, and that, frankly, town boards and city councils are comfortable looking at, and others that they're not. And one of those areas is the issue of brownfields or existing environmental contamination, and that could be contamination in the ground, contamination in a building, but contamination, you always want to say somewhere in the back of your mind, well, the Department of Labor or the Department of Environmental Conservation or somebody else will deal with this issue. This really isn't our issue. And what this case stands for is the proposition that you need to advance the record enough so you have enough information in the record about how the site's going to be cleaned up or how the property is going to be appropriately demolished so you don't have asbestos and lead paint and other problems like that. Now, it may not take much in the record, but again, you can't defer the issue to another agency. In this case, they were demolishing a building and they were then turning around and constructing a performing arts center on the building. And I don't know if any of you work in contamination or cleanup of gas stations and things like that, but one thing you always find is if you think you have a clean parcel and you're going to take down a building, you find stuff under the building. So that's, I can tell you that that's pretty much invariably the case. So, so the problem in this case was the city said, well, when we do the demolition of the building and when they start the construction of the Performing Arts Center, we're going to monitor whether there's contamination. Admirable, important, but not sufficient. You really need to look forward and figure out how the contamination is going to be cleaned up. In this case, the court said you could have issued a conditioned negative declaration. They could have required the applicant to prepare a plan for addressing the contamination and made that part of the record and just issued a negative declaration. But they couldn't defer the issue. In addition to establishing who gets to sue and what claims they're qualified to make, the last issue is, did they raise the issue in time? All right, and the concept of did they file the lawsuit on time is called statute of limitations, all right? And the way the state law is set up, you all at the ZBA and the planning board level have the shortest statute of limitations out there, 30 days. So if you file your paperwork appropriately, anyone who's aggrieved by your decision has to file within 30 days. All right, and again, on the end of, with the goal of preserving the decision that you made, the most important thing that you can do is file your decision as quickly as possible with the town clerk. The decision, the minutes, have to be filed with the town clerk. And each time you file it with the town clerk, it should be stamped received, or there should be some way to be able to prove that it's been filed with the town clerk, because that's the critical date. And there have been cases, I didn't bring examples along, where filing draft minutes is sufficient to start the statute of limitations. So in this case, somebody was complaining about an area variance that a hotel had received, and the at issue was whether it was an exempt type 2 action that didn't need to be reviewed under seeker because it was exempt, or whether they should have followed seeker, evaluated the environmental impacts, and made a determination of significance. So, but in this case, the people who brought the lawsuit didn't even get to raise the issue or discuss the issue because they didn't file the lawsuit within the appropriate period of time. So what judges like to do is they like to say, that's it. That's the end of the litigation. They're trained as jurists to try to defer to other bodies, other legislative bodies and decision makers, and to make sure that whoever's bringing a lawsuit has followed the appropriate procedural sequences. So statute of limitations is always a key issue. Does anybody have any questions about that? How many people on planning boards and ZBAs know that you need to file your decisions with the town clerk? Okay, so quite a few of you, which is great. The law is very clear on this point. The law is if the statute of limitation has passed, then your opportunity to sue has been cut off. This, again, is a decision, say, by a planning board. So you come to a planning board, you ask for site plan approval, they give you site plan approval, they adopt a resolution, and they file it in the town clerk's office. That starts the 30 days running. All right, now there are some rare instances where if the planning board has failed to refer to county planning, that can cause them problems in terms of never having the statute of limitations start running. But for instance, like you see up on the screen here, making an erroneous seeker determination is not a jurisdictional defect. So if you're a board and somehow you're having an off day and you declare an action, a type 2 action, and you proceed to approve it, even though you were wrong, if the 30 days is up, your decision stands, okay? So, and that's that, and the goal there, again, is just to not have endless lawsuits. That's the goal. And the state legislature is the one who establishes the statute of limitations. The question was, if you refer it to county planning, if it's something under the general municipal law that you need to refer, then you have to wait to make your decision until you've heard back from county planning. And that's sort of a true statement. If you refer a complete application to county planning, and the question of whether or not it's a complete referral is a term of art. If you make a complete referral to them, they must get back to you within 30 days. If they don't, then you're allowed to go ahead and make your decision. In most cases, with the boards I work with, they wait to get the decision back from county planning. It's usually, it got lost in the mail, my dog ate it. You know, it's not really an issue of not wanting to have the county planning board's input. But we're going to talk later about a county planning board that was acting in bad faith, which gave rise to another problem. I think it might be this case, in fact. This is Clear Skies over Orangeville. This is a case about a town board that adopted a wind law, which amended the zoning to provide for the orderly regulation of wind towers, which large wind towers, we're talking about the 300-foot tall wind towers that are used to generate electricity. And what the board did in that case is they issued a negative declaration on a type 1 action, and they had an incredibly extensive record showing that in evaluating the wind law, they had looked at all the potential environmental effects that could occur as a result of a wind tower being built. So they looked at low frequency noise, they looked at visual impacts, they looked at shadow flicker, which is a type of visual impact. They discussed what would be the appropriate buffer to residential properties, what should the decibel limits be in terms of the noise produced. They looked at agricultural restoration plans, which is once you're done with construction, how can a farmer continue to use the property? They looked at birds and bats, how will birds and bats be affected? And they also looked at electromagnetic fields. And what the people argued in this case, the people that were challenging the decision, argued that this was improper segmentation, that they should have looked at a specific plan for putting wind towers at specific locations in the town. And what the court said was, no, that's going too far. That's not necessary. There were no project applications pending, so there wasn't a specific project they could have looked at. And they didn't have to create a project and analyze it because that would have been speculative. And the court took a very pragmatic view of this and said, look, the purpose of the zoning amendment is to set standards for these projects. It's not, it's a good goal. It's a goal to make sure that when somebody brings a project before the town, that the noise and visual effects and all the appropriate studies will be undertaken. And they also said, you have to consider that in the past, public utility uses were allowed in pretty much every district in a town, and that's still true in many towns today. So in fact, the adoption of this zoning law was actually more restrictive, arguably, than what the town board had in place at that time. And here's the county planning board acting in bad faith. They made a referral to county planning. County planning said, your referral's not complete, and we're going to table it. And so they said, well, what do you need? And the county said, well, we think we need the following things. So they sent them the things that the county planning board wanted, and the county planning board just refused to act. So what this case stands for is a county planning board cannot prevent a town board from adopting a zoning law by continually tabling a referral. But it is I'm trying to think of the best way to say it, it's fertile ground for lawsuits. Anytime somebody brings a lawsuit, they try to allege a failure to comply with the general municipal law. So making sure that you, if you're at all in doubt, refer it to county planning, that's the best approach. If you can wait to issue the decision after you have the recommendation from county planning, wait a month. It's not worth the risk of having something go wrong procedurally. And this case was also interesting because they had made a claim that it was inconsistent with the comprehensive plan, and the court said there was only one sentence in the comprehensive plan, and it said that they wanted to encourage the development of alternative energy projects. So it was, in fact, consistent with, the rezoning was consistent with the comprehensive plan. And we don't have enough time to get into the ethical issues associated with the challenge as well. I called this case the kitchen sink because this case is a very interesting case to me because in addition to representing planning boards, occasionally I represent developers and developers who are proposing large projects for economic development. And this is exactly what was proposed in this case. It was a Verizon super data center, and it was being located next to a coal power plant, okay? Now, Everybody here knows that municipalities derive a lot of real property tax revenue from existing power plants, particularly the big old coal power plants. And the goal of the economic development in this case, looking forward to the eventual closing of coal-powered plants, was to ensure that the municipality would have tax revenue to replace that when it was gone. And one of the ways to do that is by promoting new and less environmentally damaging economic development. So the town board acted quickly to approve this project. They issued a negative declaration, they adopted planned unit development legislation, and then the planning board issued area variances and the zoning board issued area variances and the planning board issued a site plan approval. And it all happened really quickly. They followed all the procedures, but they did it in about 3 months. So there was a neighbor who complained that the project was too big, that it needed an environmental impact statement, that the town used draft documents which were prepared by the applicant's counsel but reviewed by the town's attorney, and that the review time was just too short. It was a rush to judgment. And the court in that case ruled with the municipality on all grounds. They said, you have to look at the specific facts of a case. You can't make claims just because something happened quickly or expeditiously, and it's a large project. And it's an interesting case because it stands for the proposition that if you do it right, you can do it quickly. There's no benefit to dragging things out if, in fact, you have a plan that comes in and it's exactly what the municipality is looking for, and it's located in the right part of town, and it's, in fact, more environmentally benign than the surrounding uses. So, I like that case. This case, Rogers versus the City of North Tonawanda, this issue comes up a lot, which is, what do you do when you have an action where part of the action is exempt or type 2 and part of the action is not exempt? How do you deal with that? And the court very clearly said in this case that if you have an action that's a type 2 action, then you don't need to cover it under seeker just because it's loosely associated with another action that is not exempt. And in this case, it was the replacement of a stormwater sewer system next to a property that was going to be developed as the town park. And the court said, you don't need to look at the environmental impacts of this. It's a type 2 action. Look at the park, look at the issues associated with the park separately, and that's completely appropriate. So anytime you have the opportunity to have something be a type 2 action, there's nothing wrong in proceeding with other related actions if they are covered by seeker. And there have been a few additional cases that have come out recently that I just want to mention to you if we have, and we have plenty of time. So, and we have plenty of time for questions when you have those. The first case that I want to mention is an open space case. This case is older, but this issue comes up all the time. It's O'Mara versus the town of Wappingers. And the question is, if a planning board requires an applicant to create open space on a subdivision plat, and if that open space is noted as open space that's going to continue in perpetuity, can that open space be later built upon by a subsequent owner of the property? And the answer to that question is no. If something is noted on the subdivision plan as open space and it's later sold at a county auction and somebody doesn't go back and look at the subdivision plat and they propose to build on it, the town is within its rights, and any surrounding property owners are within their rights to enforce that open space requirement. So even if there's not a conservation easement or a deed restriction filed in the chain of title, merely having open space on the subdivision plat will evidence an intent not to have that be built upon. And this issue comes up because you often have agencies saying things like, well, a deed restriction is not strong enough, you need to have a conservation easement. And the reality is you don't have to have either of those things if the subdivision plat is filed with the county clerk's office, as they all must be in order to be legally effective, and they show open space. I'm not saying that those other vehicles, the deed restriction and the conservation easement, aren't a good idea. I'm just saying they're not strictly necessary.
Do you have to use the language perpetuity on the map to more or less enforce that it's an open space in perpetuity?
It would be good to use the word perpetuity, or it would be perfectly acceptable to say to be open space, never to be built upon, to be preserved for wildlife and recreational purposes. Another case, which I believe everybody at this point is familiar with, but I always like to mention, is the Kitteridge case, which stands for the proposition that when you're doing an environmental review of a property, you need to look not only at threatened and endangered species, but you also need to look at regular old species that may be affected by the project. And this is generally covered these days by a more generic environmental survey that your biologist or botanist may do on the property, as opposed to just getting a listing from DEC saying there's no endangered species on your property. The other case I wanted to mention is DEC adopted, I think it was last fall, a new endangered species regulations, and they're actually an improvement in many respects over the program that was in place previously. However, their regulations were challenged by an association of towns and villages on Long Island. And in that case, the court determined that the challenge was not going to be heard because the issue was not ripe. The court determined that the only way they could appropriately look at the endangered species regulations and the new procedures was in the context, bless you, of a specific project. So right now, those regulations are still in place and in effect, and what it means is that DEC may be more of an involved agency than they have been in the past on smaller projects where these endangered species may be affected. The next case I just want to mention briefly is Gabrielli versus New Paltz. New Paltz, the town of New Paltz has been trying to adopt a wetlands regulation since the year 2004. They adopted a previous set of regulations which were also overturned, and this most recent set were overturned as well. And interestingly, they were overturned on constitutional issues. And the court determined that it was so impossible to try to figure out what was going to be regulated that their law was unconstitutionally vague. And honestly, it's one of the few cases I've seen like this. The court said, a statute is unconstitutionally vague if it fails to provide a person of ordinary intelligence with a reasonable opportunity to know what is prohibited, and it is written in a manner that permits or encourages arbitrary or discriminatory enforcement. And at issue in the case of this wetlands law was very small vernal ponds or vernal wetlands that may only be available to see during certain times of the year, and which the town lacked the resources to pre-identify for people. So, so it's interesting. You see in some of the language a lot of the concepts that courts like to fall back on. You shouldn't have to be an expert. You should be a person of ordinary intelligence, be able to figure out what you can do here, and it should be somehow reasonable. The next case I wanted to mention, or situation, is Article 10. The public service, the New York State Legislature has adopted a new law regarding the siting of actually relatively small electric generating plants. So what it does is it takes the authority for reviewing those projects from the local municipalities, and it gives it to the New York State Siting Board. And the New York State Siting Board is really part of the public, it's not part of the Public Service Commission, but it's the Public Service Commission staff that assists the Siting Board. So one of the key issues in these types of cases is whether the town board has unreasonably restricted the proposed project in its zoning regulations. If your restrictions are reasonable, the siting board will use the local laws as substantively as part of their decision-making process. And interestingly, as soon as the law was adopted, somebody sought a declaratory ruling from the Public Service Commission as to whether certain laws in a town were unreasonably restrictive. So one of the things that you may want to have your town attorney look at is, in preparation for dealing with projects like this, whether the town needs to have a law that will come alongside the Article 10 process and make sure that the town's interests are being taken a look at. In addition to that case regarding the Verizon data center, the other case that I found really interesting, and this is the last one, I promise, is the Fortress Bible Church versus the town of Greenburgh case. And this case is a RLUIPA case, Religious Land Use and Institutionalized Persons Act. And it's a decision by a federal court, not by a state court, because this claims of violation of RLUIPA are dealt with at the federal level. So you could tell the federal judge had not decided a land use case before, and he decided it in like 300 pages. And he obviously found the history of the case very interesting, because he goes through all the things that happened to this Pentecostal church when they came into the town of Greenburgh and they sought site plan approval. Not an area variance, not a zoning approval, not a zone change, but just site plan review, which was handled by the town of Greenburgh town board. So it was a use permitted as of right. There were other churches in the town, and there was some question as to whether they needed an area variance for parking, but it was, believe me, it was a very minimal thing. It was not a big deal. So they started the process, and I'm talking about this case because this is an example of what you don't ever want to do, okay? And it's a really egregious example of when someone's going to be able to successfully make a claim in federal court against a municipality. They started the application process in November of 1998, and by December of 2003, they had not completed their review of the case. So first of all, they went through a really long process of deciding whether or not they could issue a negative declaration. And the applicants got the sign-off of all other involved agencies like DOT and everybody else. And the town planner was satisfied that they had mitigated as much as they could and that they had incorporated designs into their proposal for traffic and to deal with issues that were raised by people. But in spite of that, the town board decided to require them to do a draft environmental impact statement. And they decided to do scoping, even though they had been for about a year going through the negative declaration process. So the first thing to take away from this is, if you as the board believe that an environmental impact statement should be taken for a project, and if it's a reasonable belief, which in this case I don't think it was, but if you're going to do that route, move to that route quickly. Don't drag out the process of deciding whether or not you can issue a negative declaration. It's much better to move forward with an environmental impact statement process than to just hang out there in limbo. And if you issue a positive declaration requiring an environmental impact statement, then move quickly through the process. Try to set deadlines so that you get the draft environmental impact statement and you can review it, because it wasn't accepted as complete until October of 2001. And then the whole process just kind of fell apart from there. But there's, in addition to dragging out the secret process, which you absolutely cannot do for projects that are covered under RLUIPA, they also made it very clear in the record that they wanted the church to contribute a fire truck, and that they wanted the church to sign a pilot agreement which would require them as a charitable organization to pay taxes. You cannot do that either, okay? It was just incredibly egregious, and every other agency that was involved had no objections to the project. The court deliberately went through other projects that were approved in the same times using negative declarations, and there was a church expansion by the Baptists that was approved like in 3 months. There was a commercial project which had much more significant environmental effects that was approved with a negative declaration in like a year. So you really, this case is probably the most egregious example of how to violate RLUIPA that I've ever seen. And I think most people, would step back from that and say, well, the positive takeaway from this case is, if you treat religious organizations like everybody else, and you don't single them out for special treatment or ask for things that you're not entitled for, then you're not going to be held responsible for violating RLUIPA. But if you do the opposite of that, you can pretty much guarantee that they'll sue you in federal court and win. And in this case, the court was very disgusted with the attorneys involved. And I know there's very few of us here today, but they were particularly disgusted with the attorneys involved because they didn't produce evidence, they didn't preserve evidence, and they were actually sanctioned for the way in which they had handled the application. I hope you have a great day and enjoy the rest of the planning classes.